Okay, ladies and gentlemen, welcome back to class. This is CRIJ 1307, Court Systems and Practices. So let's start with chapter 10 of your textbook on this PowerPoint lecture today. Today we're going to deal with chapter 10 and we're going to talk about from arrest, when an individual is arrested for a crime, and from the time of arrest to bail and to arraignment. Our learning objectives. We are going to be able to define the two methods of estimating the amount of crime in the United States, discuss how arrests made by the police impact the criminal court process, list the 4 ways that criminals are formally charged in court, and the major actors in each of these important documents. List the 4 most common ways that defendants secure pretrial release. Compare and contrast laws on the book and laws in action approaches to bail setting, including the overall effects of the bail system on criminal defendants and their cases. Explain the role bail agents play in the criminal justice system. Contrast how the law on the books approach to criminal justice and the law in action perspective offer contrasting views of the preliminary hearing. Explain why some jurisdictions use grand juries extensively and others do not. Delineate the 3 major reasons for case attrition. Describe the 4 layers of the criminal justice wedding cake. Now let's talk about crime. There's been a dramatic increase in crime from 1960s to 1980s. We get our crime report from the FBI sources, and one of the major sources include the Uniform Crime Reporting, otherwise known as the UCR. It's a form of voluntary reporting to the FBI. It looks at index crime like type 1 offenses, the 8 most serious crimes. When you look at the part 1 index crime, the most serious offenses are under the violent crimes. We have murder and non-negligent manslaughter, forcible rape, robbery, and aggravated assault. We also have, under the part 1 index crime, we have property crimes such as burglary, larceny/theft, motor vehicle theft, and arson. Then we go to part 2. Under the violent crime of part 2, we have simple assault. Under the property crime of part 2, we have embezzlement, forgery and counterfeiting, fraud, stolen property offenses, vandalism, disorderly conduct, driving under the influence of alcohol or drug, driving under the use of drug at the same time, such as gambling, drunkenness, liquor law offenses, loitering, prostitution, offenses against the family, e.g., in other words, for example, child neglect, sex offenses other than forcible rape, such as incest, vagrancy, weapons offenses, curfew and loitering offenses, and runaways. We also have another source of crime reporting, otherwise known as NIMBRS. It stands for the National Incident-Based Reporting System. The incident base is based on location of crime, number 1, whether the crime was completed or attempted, type of weapon used, type or value of property damaged or stolen, personal characteristics of offender or victim. Arrest. We'll look at the quality of arrest. Police have a lot to do with what happens in court after arrest. What are the keys to conviction? Collection of tangible evidence, locating cooperative witnesses. Police departments differ in quality of arrest. Under arrest, we have a lot of swelling criminal dockets. In other words, a lot of court cases that are currently ongoing. In the federal court, number of suspects prosecuted by U.S. attorney increased by 55% from 1982 to 2002. In the state courts, felony prosecutions have increased 25% over the last decade and a half. In other words, in the last 15 and a half years. Much of the growth in the court docket is due to drug-related cases. Let's look at under the initial appearance. We have a case of Gainstein versus Pugh in 1975, where the court looks at the case. The court established that arrest must occur within a few hours or a few days of the incident. Generally 48 hours, excluding weekends, as stated by the Supreme Court. Most misdemeanor defendants enter a plea of guilty and are sentenced immediately. Felony defendants can offer a plea at this point, so it is a brief affair for felony defendants. Charging. Under the charging documents, we have complaint, information, arrest warrant, and indictment. Those are the stuff that are written on the charging document. Laws on the book, prosecutorial control. Prosecutors decide whether and what charges should be filed. In other words, they have a wide range of latitude when it comes to discretion that is given to them and the use of that power. No review of decisions of the prosecutor. Laws in action. We look at police influence on the laws in action. In some jurisdictions, prosecutors differ to the police. Power has been essentially transferred to the police. In some jurisdictions, the police influence the prosecutor's decision. And also in some jurisdictions, prosecutors control filing of charges. 25 to 50% of all felony arrestees do not get charged. Courts and controversy. Let's ask ourselves, should prosecutors set high standards for charging? It depends on what jurisdiction you have and what kind of criminal element they are dealing with, especially when it's a criminal that keeps committing crime like a recidivist all the time. Let's look at bail on the laws on the book. The monetary bail system. The court has ruled that bail cannot be excessive in the case of Stark versus Boyle. The 8th Amendment, bail procedures vary by jurisdiction according to seriousness of the crime. We have different forms of bail, and it's also a form of preventive detention. Under the forms of bail, we have ROR, otherwise known as release on recognizance. Here, judges release a defendant from jail without monetary bail if they believe the person is not likely to flee. Such personal bonds are used most often for defendants accused of minor crimes and for those with substantial ties to the community. Cash bond. Under cash bond, the accused must post either the full amount of cash bail with the court or a percentage of it in the form of a cash bond. All of this money will be returned when all court appearances are satisfied. Because it requires a large amount of cash, this form of bail is seldom used. For example, bail is set in the amount of $10,000. Most persons cannot raise that much money easily and quickly. Property bond. Most states allow a defendant or friend of relatives to use a piece of property as collateral. It could be a house or a land. If the defendants fail to appear in court, the property is forfeited. Property bonds are also rare because courts generally require that the equity in the property must be double the amount of the bond. Thus, $10,000 bond requires equity of at least $20,000. Bail bonds. The arrestees, or in other words, the defendant hires a bail agent, often called a bail bondsman, who posts the amount required and charges a fee for services rendered, usually 10% of the amount of the bond. Thus, a bail agent will normally collect $1,000 for writing a $10,000 bond. None of that money is refundable, and that's how the bail agent or a bail bond company makes their money. Context of bail setting. Trial court judges have discretion in fixing bail. Part of what they consider is the flight risk or non-appearance. In other words, whether the defendant will show up in court at a later date for their hearing. And then they also look at whether the defendant is a risk to themselves or to others. And they also look at situational justice, the situation or the kind of offense that was committed. Bail agents and bounty hunters. Under the financial resources, you use cash or property bail, conditions of bail posting, and jurisdictional constraint. Effects of bail system. We will look at direct and indirect effects on defendants. You look at jail conditions, race and ethnicity of the defendant, failure to appear. If you fail to appear during the court hearing, a bench warrant will be issued or capes. And then we also look at the case disposition. Pre-trial release is a non-financial conditions of release. Some of those conditions might include travel restrictions, court-monitored supervision, residence, employment. In other words, the person must be gainfully employed and live close by. Drugs, stay away from drugs, or you have to attend alcohol or drug mental health programs, and not having access to firearms. During the preliminary hearing, the magistrate would determine if there's probable cause to hold a defendant. Under laws on the books, again, we look at preliminary hearing. The judge or the magistrate weigh the probable cause, like I said earlier. Preliminary hearing is first time someone other than a law enforcement official reviews the case. In grand jury states, a prosecutor can still go to the grand jury if a magistrate rules there is insufficient evidence. Prosecutor has to establish probable cause of a crime and that the defendant committed the crime, and they will be bound over for adjudication. Factors weighed by defense attorneys in deciding whether to demand a preliminary hearing is based on practices of the local prosecutors, strategic and tactical consideration on the part of the defense attorney, client control, overview of evidence, and opportunity for discovery. On the laws of the book, let's look at the grand jury. It's a form of shield and sword, buffer between state and citizen. They have investigatory power. If the grand jury issue an indictment of a crime, it is called a true bill. And if the grand jury refuses to issue an indictment, it is otherwise known as no bill or no true bill. Many legal protections not applicable at grand jury stages. Authority to grant immunity from prosecution. Under there, we have transactional immunity. And the use of the immunity, then we also have a subpoena. Under the subpoena, if you didn't show up for a grand jury hearing, they could issue a contempt order. Under laws and action of the grand jury again, prosecutorial domination. In theory, prosecutor functions as legal advisor to the grand jury. In practice, prosecutor dominates grand jury, often function as a rubber stamp for prosecutor. And some people have been complaining about reforming the grand jury, and this will be left to individual states to decide whether they want to reform their own grand jury, or even if they even have a grand jury system. Trial courts of general jurisdiction. Here, defendant is formally accused of a crime. The defendant enters a plea, signifying to courtroom work group that the defendant is likely guilty of the crime charge. Three facets of discretion: legal judgments, policy priorities, and personal standards of justice. These are the three things that prosecutor looks and uses as a form to exercise the power of discretion. The criminal justice wedding cake. Under the criminal justice wedding cake, we have 4 layers. We have the celebrated cases, mostly when you have an actor or actresses or big name personnel involved in major crimes. And then we have the serious, followed by serious felonies, number 2. And then number 3 are lesser felonies. And number 4 are lower depth crimes, such as misdemeanor offenses. Ladies and gentlemen, and that's the end of chapter 10.